And now it is time for IP in the News, everyone's favorite segment, my favorite segment for sure. Today we're going to be talking about tattoos, right? And LeBron James. So how can you go wrong with tattoos and LeBron James? Well, it turns out that tattoo artist Jimmy Hayden put a tattoo on LeBron James' arm
that he designed himself. Jimmy Hayden designed.
That Jimmy Hayden designed. And then what happened next?
Well, and then LeBron James, his likeness was made into a character on a video game.
Right.
So. And they copied the tattoo into this character on the video game. And the guy that created it said, hey, I should get paid for that.
But of course, the court disagreed. And it went before a jury in Ohio. They decided that the tattoo artist, Jimmy Hayden, gave LeBron James an implied license when he did the tattoo. And LeBron James paid for it. And therefore, he had no claim against the gaming company for using his tattoo on the likeness of LeBron James.
And I think some of the logic was it kind of becomes part of your body, so it's kind of you.
Which is not super precise legal reasoning, in my opinion.
Because it was funny because the artist did design it. So it was a unique artwork created by this artist, but he put it on LeBron James. So who does it belong to?
Well, I mean, under normal copyright law, the creator of the work owns the copyright. And unless there is an agreement between the creator and the user, the copyright stays with the creator. So in this case, in my opinion, probably should have stayed with Jimmy Hayden unless LeBron James and Hayden had like some sort of deal that, okay, I'm going to make this tattoo for you, LeBron. You own all the rights. Right. But based on what we've seen, there was no such agreement like that. And so I'm not really sure that this was a correct decision, but I guess the moral of the story is if you get a tattoo and you're a famous person and you think you may end up on a video game, maybe what you should do is make sure you have the right deal with your tattoo artist so you don't get sued. So
right.
Anyway, so that's our IP in the news, but I'd like to ask our amazing guests what they think about this situation. And Natalie, you're there listening to all of this. What are your thoughts here?
Well, I mean, best to just not get a tattoo, that's where I am on that. But I see our guy Mike here. He's prepped. Yeah, I don't know. I know there's like copyright, like listening to you describe the law makes me think like, okay, well, maybe there is a side, but to me, if he exchanged compensation for the work onto his body, then it becomes his. So I'm pretty okay with the ruling.
Okay, well, that's
not that LeBron is my favorite or anything.
Yeah, I mean,
always beating up on our poor New Orleans Pelicans. So
so how you come out on this depends on whether you're a LeBron fan or not, I guess.
Yeah, right? Probably, huh?
So Justin, what's your take here?
Well, I'm just going to call Natalie out for saying not to get a tattoo. I mean, Natalie, you sell tequila. Let's be honest. Right? No, wasn't this story
conservative tequila drinker?
Sure. Wasn't this story? It was similar to Mike Tyson, right? So like Mike Tyson had a big tattoo on his face, and it was in the movie Hangover. Do you remember this? Are you guys familiar with the story? So he had the tattoo, and I don't get the story exactly, but I think they had to go back in the movie and digitally remove the tattoo. Is something they did in the Hangover movie to get rid of his likeness. So what a weird thing. I mean, with AI, this is gonna be more of an issue. It sounds like kind of a silly issue, like it's very specific to like a celebrity in a video game. Who cares? But the more we have digital likenesses of people, I think the more this issue might come up, right?
Yeah, I think so too.
That also excellent point. So, Mike, tell us. You're flashing your tattoos here on the Zoom, so please give us.
I only did that for Natalie's. For Natalie's.
I mean, I'm all for whatever.
No. I only did that for Natalie's benefit.
Did you design your own tattoos, Mike, or did you?
I did.
So you own
but
them.
the artist still has license to change them. I mean, just because I told him, hey, look, this is what I want, it never turns out exactly like that. They create them. What my question for you, Richard, is what's the case law, the prior case law for this? I'm sure this isn't the first tattoo artist who has ever had his art that somebody else has done this, and there had to be precedents that the attorneys put forth that said, hey, look, this isn't the first time that an artist has put a tattoo on somebody and there was a picture taken of somebody wanted money for it.
Well,
Obviously,
way to
this happened before.
Well, way to put me on the spot, Mike. But
I
you know, I will say that in fact, the case law on this is mixed. In some cases, the courts have found for the artist. In other cases, they haven't, right? And so there's still some ambiguity. Copyright is always really fact specific. So, I mean, you can just imagine the Ohio jury kind of liking LeBron James, right? And just like, well, we're going to find for him no matter
Right.
what, you know?
Right. Yeah. Well, there were a
Yes.
couple other in this article that say that they were dismissed. So doesn't sound like the tattoo artists really have a lot of rights in this.
Right.
So
Well,
And-
a tattoo artist they make their living by whatever they design and draw. They sell that to the person that they're putting this art on. So it's kind of hard for me at the same time, after spending literally thousands of dollars having somebody put ink into my body, for me to say, oh, now I got to give you money from something else. I'm pretty sure that the gaming company didn't give LeBron extra money just for putting the tattoo on there. They just gave him money for having his likeness on there.
Maybe they should have, though. That's the problem. I mean, you're going to have OpenAI scraping the entire web of all the artists' work and then just recreating that work in their style for free without attribution. I don't know what the answer is, but that doesn't seem right.
But you know,
Yeah.
the sort of traditional
Right.
copyright, like for like really well-known photographers, they take a picture and they'll give you you pay for that headshot. They'll give you the rights for a website or a brochure, and they just sort of divvy out the rights for that, and you pay each time you use it in a different way. And so I kind of, when I'm thinking of this, I'm kind of thinking of it like, you know, that's the traditional model, is the photographer who keeps all of the slides and licenses out each individual use. So, so it's a challenging question for sure. And obviously, you know, tattooing is a little different than photography, but you know, maybe not. So anyway,
so
the moral of the story is, before you get a tattoo, call your intellectual property lawyer.
Good plug, Richard. Good plug.
Noted.